Berg is professor of law and bioethics at the Case Western Reserve University. And she serves in the, what now is called Cases School of Law, and the Department of Bioethics, Cases Medical School. She teaches law and bioethics, and her publications and research span a variety of areas, including informed consent, research on human subjects, reproductive law, and ethics, confidentiality of medical information, mental health law, professional self-regulation, and new medicine. And before I go ahead and I turn things over to her, I want to remind people that our next Dean's Foundation Visiting Scholar in Humanism will be Arthur Kaplan. He'll be here on January 23rd, visiting from the University of Pennsylvania, where we'll be speaking on ethics and politics of stem cell research. So I give you today Jessica Weiland-Berg on end-of-life decision-making and incompetent patients, lessons from Chicago. Thank you.
Hello. Thank you for inviting me to speak today. What I'm going to do is start and spend a couple of minutes reviewing for you some of the details of the case. For although most people are aware of the case, very few people have spent the time to take a look at the case itself and see how things progressed. What I'm actually going to do is a very short timeline. I want to stress short because if you actually trace back and look to see at the amount of both litigation and details that went on in this case, it is a phenomenal length and amount of material. So we will start, if I can get this to move forward for me. Oops, it doesn't do it here. There we go, just a slight delay. Okay, so Terry Schiavo suffers a cardiac arrest in 1990. She's 27 years old. There's some suspicion that it might have been caused by a potassium imbalance subsequent to an eating disorder. So this is a theory, it's not proven for sure, and there's other reasons why you could have a potassium imbalance, but this is what is the most likely explanation for why at 27 with no other health history, she suffers a cardiac arrest. This happens to be 1990, the same year that Cruzan is decided by the United States Supreme Court. Sort of an interesting side note. Cruzan is the one case in end-of-life decision-making for incompetent patients that's made it up to the Supreme Court prior, unless you count the physician-assisted suicide cases that came more recently, that has shown that we have sort of a framework, at least on the legal side, of decision-making for incompetent patients. Her husband of 6 years is appointed as guardian, and the parents don't object. This is not strange, right? This is sort of baseline what's going to happen in these cases, and nothing at the time is any indication that he would be an inappropriate guardian. They've been married already 6 years, so he's not even new to the situation. And everything seems to go along fine for at least a number of years. She's kept in nursing homes, and she's given a wide array of treatments. Now, she's actually given treatments for 8 years at least. And this is far beyond the time which medically it would have been recommended to continue to try treatments. So there's no doubt that at least for a long period of time, the family continues to seek out a variety of different treatments past the point where the medical recommendations start to at least say, look, we're unlikely to get improvement if we haven't at this time. I've heard different reports from people, but most people that I've talked to will say 2 to 3 years for somebody who's in the medical state that she was in before you start to say it's extraordinarily unlikely that we're going to see improvement. They actually go beyond that. During this time period, there's a malpractice settlement in 1992. Of this, $750,000 is allocated, put into trust for her care, so not accessed by the family, and $300,000 is given to her husband for his losses. In 1993, we see the first disagreement between the parents and the husband related to care. Here, not the issue of stopping her care, but just a disagreement between the parents and the husband. And at that time, they actually go to court and they request he be removed as a guardian. The court, this initial court that heard the case, put in place a guardian ad litem, which is basically a person who's going to come in and think just in terms of her interests and try to figure out what should be done in her case and whether the guardian in question, here her husband, was making appropriate decisions. And the answer was yes. He seems to be doing everything appropriately and in her interest, and the court declines to remove him as guardian, and things are quiet again for a number of years. And then in 1998, here now again, a number of years have passed, and we're continuing on in this situation. Her husband petitions for removal of her peg tube. At this point, sort of, everything kind of goes to pieces, and the parents oppose the removal. The first case that gets into court, the judge rules that the guardian made an appropriate decision, this is what Terry would have wanted, and the tube should be removed. Appeals immediately follow, and during the appeals period, there's periods of time where the tube is removed, and then a court above will stay the removal or reinsert the tube. So we actually have at least 3 times where the tube is removed and where a court takes action after that over this time period. One of which, by the way, is a civil suit that the parents file. So they're filing suits at different points saying, A, this isn't what Terry would have wanted. At other times they're trying to claim he's not the appropriate guardian. And at still other times they actually file a civil suit against the husband, which again the court says, the judge says, well, if I have to decide the civil suit, we better make sure that she's alive during the course of the civil suit, so we'll put the tube in again. That decision, by the way, isn't made at all based on what she would have wanted or not. All of these putting the tube back in times are not courts saying you made the wrong decision. They're all courts saying basically, we need to make some decisions here. We'll wait to remove it or we'll put it back in just until we've made the determination of what she would have wanted. So at no point during this entire process does any court say husband isn't an appropriate guardian or that the husband isn't making an appropriate decision. All they're doing is saying, well, each time you bring us a case, we need to make certain decisions about it. At one point, 5 doctors are appointed, 2 from the husband's side, 2 the parents choose, and 1 that the court chooses to examine her. Of those, 3 say that she's in a persistent vegetative state, and the judge agrees with them. So in each of these times, basically, they go through the court system. The judges agree that this is appropriate to withdraw the feeding tube and do so. Following this, the parents go to the Florida legislature, which issues what's called Terry's Law. Terry's Law essentially said that for someone on a specific date whose family doesn't agree about the treatment, who has an issue of treatment, who's incompetent, can't speak for themselves, and has an issue of treatment related to food and hydration, the legislature, the governor, can issue a stay. Basically order a tube reinserted. And the way the legislation was framed, it applied only to Terry Schiavo. There was no other patient in Florida that met the 3 criteria as of the specific date that they were talking about. So essentially they passed this law to give the governor the ability to do what the courts were unwilling to do, which was step in and say, we're going to reinsert the tube. This case makes its way up through the court system. Now, on the question of whether the Florida legislature was doing something appropriate, and the courts that all hear this say no, it's unconstitutional. A state legislature can't authorize the governor to do something like this, and the Supreme Court actually won't hear this particular case. The Florida Supreme Court rules it's unconstitutional. The U.S. Supreme Court basically left that decision stand. They then go to Congress, the U.S. Congress. The U.S. Congress passes special legislation mindful of the Florida situation, and by the way, Florida then refuses. The Florida legislature, I think the House went ahead and tried to pass legislation against. The Senate said, no, we're done with it at this point. I might have gotten those confused. But after they get Terry's Law struck down as unconstitutional, the Florida legislature is unwilling to act again. The U.S. Congress, realizing they're not going to pass an act that says the president now has the authority to reinsert Terry's feeding tube, passes a special law essentially granting federal court jurisdiction. Why do they have to do this? Because they've exhausted at this point every other possibility. This has been heard by more courts than almost any other case you can imagine. It's been heard now in front of legislatures, which is unheard of in this situation. So basically what they do is they say, we'll grant federal court jurisdiction. The federal court that hears the case does exactly what every other state court does and says, husband's the appropriate guardian, he's making the appropriate decision, feeding tube gets removed. At the time, protesters flocked to the nursing home, and one man's arrested for offering, I think, about $1 million for the killing of Terry Schiavo's husband and the judge who made the determination in the case. Okay. March 31st, 2005, Terry Schiavo dies after the removal of the feeding tube. It is the same date as Quinlan was decided in 1976. Quinlan is another fairly significant case in end-of-life care and treatment. It's a New Jersey case about a young woman who's in a persistent vegetative state and the removal of her feeding tube. Quinlan case is decided. Interestingly enough, Quinlan, although the feeding tube was removed, does not, a respirator, I'm sorry, was removed in the Quinlan case, does not die. Quinlan actually lives for a number of years with the respirator removed. It's 15 years since her cardiac arrest. Her gravestone mirrors Cruzanne's in the departed date and at peace date. So Cruzanne's gravestone says the same thing. It has her departed date of the date of her accident. Cruzanne was in a car accident, and the at peace date. The bottom part, however, is different from her husband. I kept my promise. Immediately following her death, there is an autopsy that's done. The autopsy report says that it is, quote, consistent with a persistent vegetative state, notes that she would have been blind because the degree of damage to visual cortex was extreme enough that, and the links were extreme enough that there was no way she could have been seeing at all, and that there's no evidence of abuse. Governor Bush, 2 days after the autopsy, requests an investigation into the husband's actions on the date of the cardiac arrest, claims that the timing of everything doesn't seem to match up. He says he called immediately, maybe he didn't call immediately, maybe 20 or 30 minutes went by, and he wants an investigation. The first investigation comes back saying nothing that we can find has been wrong here, and eventually Governor Bush is persuaded not to actually close the investigation, and in theory sort of end things from there. The husband, Terry Schiavo's husband, buries her in Florida despite his near her parents, despite his initial claim that he would bury her in Pennsylvania where he lived. So, and it's not clear whether the parents and Michael Schiavo reconcile or not. At this point, they themselves are out of the public spotlight, except to the extent that they choose to re-enter into it. So, when I put this presentation together, and this, like I said, what do we do? We spend 10 minutes on this. This is the short version here, understand, of the timeline. I thought, what do we learn from this case? What can we think about that this case causes us to maybe not learn even new, but to reevaluate and reconsider about our situation now, about the legal framework and ethical framework, and about end-of-life decision-making for incompetent patients. So the first lesson. Despite the apparent legal flurry in this case, we actually have some fairly well-settled legal precepts for end-of-life decision-making for incompetent patients. The first of those is that competent patients have the right to refuse medical treatment, even life-sustaining medical treatment, and even if they're not terminally ill. We've actually seen this across the board in a number of different states and a number of different cases. And there are very few people who will take issue with this aspect or this framing of the legal precepts here. First of all, Cruzanne, although sometimes cited for this proposition, actually just basically says they'll assume from a constitutional standpoint that there's a right. Cruzanne does not establish the right. But it had a pretty strong statement that patients have a right to make decisions about medical treatment. And the decisions don't disappear for incompetent patients. In addition, this case and a variety of others have made it clear that there's no extraordinary, ordinary distinction, that when you talk about rights to make decisions about medical treatment, they include things like food and hydration and respiration. All of this is included in the same package. A variety of states by statute will say you have rights to make decisions about these treatments. Sometimes they put them within their advanced directive statutes, and we'll talk a bit about those. So the first thing we know here is that we have a legal baseline that tells us that you have rights here. Maybe they're constitutional rights, maybe they're not constitutional rights. In any event, they're well-established rights to make these kinds of choices. And becoming incompetent doesn't mean they disappear. Lesson 2. The default, however, in the absence of patient wishes, is continued treatment. Why? Why is the default continued treatment? Hippocratic oath, you have responsibilities as healthcare providers to provide treatment. Why else? Well, what would be an alternative? What could be our default baseline alternative? What would be our rule? Instead of the rule being continued treatment unless you know what the patient wants, an autonomy rule, what would be another one that you might say, this is the rule we follow? Think about the Hippocratic Oath. Think about your responsibilities as healthcare providers. What would you say your goal is in cases?
Withdraw treatment.
Could be to withdraw, but what? What would be a goal that you would say? It wouldn't be that you would want to say, it'd be a strange healthcare provider atmosphere that said healthcare providers should always withdraw treatment. You'd want to say, no, they treat. But you might say you have another, what was it?
Provide comfort.
Provide comfort, relieve suffering. Our goal is to minimize suffering. Our goal is a beneficence goal. We have not chosen to do this. So another thing that we know from this case and from others is that we are willing to accept a certain amount of, or we are willing to give more preference to autonomy over beneficence in a variety of these cases, which means we have to be willing to accept situations which might not make us that comfortable, which might be situations which cause suffering, in our effort to place our primary focus on autonomy. Now that could be wrong, but that is the situation we have. So it's important to sort of realize that, first of all, we have the situation, and secondly, it could be different. It doesn't have to be that. And arguably, if you look at the numbers and statistics that come out of the Netherlands in discussions about euthanasia, their shift might be away from an autonomy baseline and towards one of relieving suffering. And there's a lot of people that claim that leads to other kinds of problems. So, but ours in our situation here is going to be a baseline of autonomy. In the absence of wishes, we continue treatment. So what, lesson 3. An advanced directive would not necessarily have solved the problems in this case. When I did a ton of media interviews, actually each time the feeding tube got removed, you got calls from people who were like, do you know anything about this case? And you had to say, yes, it's been around for ages, just because you're hearing about it for the first time. And one of the interviews I did on the last part of it was with the Diane Rehm Show. Lots of fun, because I listen to it all the time. It is so exciting to actually talk to someone who you realize, they're such a part of your daily, routine, and I'm going to get a chance to do this. And her first question was, well, would an advanced directive have solved the problems in this case? And I don't think she was happy when I had to say, not necessarily. I couldn't just say, oh, yes, and everybody run right out and do one, because that would solve everything here. Why? Well, first of all, most people don't have them. So it would almost be shocking that a 27-year-old with no other reasons to have one would have written an advanced directive. I didn't write one, despite the fact that I've been teaching about them for over a decade. I didn't write one until the birth of my daughter. And because I was writing a will at the time, I thought, oh, I'll do an advanced directive too. Why not? You're filling out one legal document, you're going to get a bunch of signatures, you may as well do another one. The vast majority of people don't have these. We've seen statistics as high as maybe 20-25% of the population, but I think those are probably more likely in certain segments of the population that would think that there's a need to do them. So you get them sometimes in, say, HIV-positive populations or cancer populations that know they'll have to make decisions. It's probably more like 10 to 15% of the population at most. Why don't they have them? Well, these are not easy issues to think about. You don't want to sit down and have a decision with your family about this. I still remember getting my license for the first time, and I was in New York State, and at the time you needed to have someone sign the back of your license to be an organ donor. Now it's much easier in Ohio. They just asked me, and the person in front of me, I guess, served as a witness when I said yes. She checked the box, and we were all set. And I brought it home, and I said to my mom, will you sign the back of this? And boy, was that a mistake. Because my mom said she had nightmares for weeks after that about them coming home, and she came home and somebody came to the door and said, here's what's left of your daughter, and handed her a little bag. And I thought, oh, God, why don't you have these discussions? Well, they're not easy discussions to have. It's very difficult to make choices in the abstract. so you have to think about what would happen in that case. Well, I don't know what would happen in that case or what I would really want to have. And many people prefer family choice over the opportunity to make your own choices. Now, this is a very interesting idea. When I did finally fill this out, I filled this out with my husband, and we basically sort of went along the same lines in what we both wanted or didn't want. And we filled the whole thing out, and we got it all signed, and we put it down, and he said to me, you know, I just need you to know, I don't think I ever actually could withdraw treatment for you. And I thought, well, that's good information to know. And in fact, I do recommend to people that they talk with their surrogates to know these things. And I've had students who said to me, I could never designate, you know, mom because I know she'd never do what I wanted. And I thought, you know, but here's the thing. I'd actually prefer he make whatever decision he feels most comfortable with. That's more important to me. Now, it may not be more important to everybody, but in my world, and it turns out when we do some surveys of patients and what they want, it's more important that the family have an opportunity to make choices than they themselves pick exactly what they want or not want to do. In which case, some people might be cautious about doing an advanced directive because basically they say, look, you know, my family will be making these decisions, let them go ahead and make the decisions. Now, talking a little bit about why you still might want instructions and what they could do. Another reason why it might not have helped in this particular case is they're often not available. I can't tell you the number of times I have walked in to do a case consult on something and I open the medical record and there it says, patient has an advanced directive. And I say, great, where's the advanced directive? I don't know. Well, you know, you look through the entire medical record, these things are huge. A good portion of the medical record is often stored somewhere at a different hospital somewhere. They've got it taped to their refrigerator. It never even made it into the medical record. Sometimes you can't even find them. So I often know a patient has one. Why do I know a patient has one? Because we're all legally required to ask. We are not legally required to actually get our hands on a little document. We need to just ask if you have one. If you don't, we need to give you some mechanism for filling it out. So they're often not there. When they are there, they're not specific enough or they're too specific. I don't want anything that unnecessarily prolongs my life. Okay? I don't know what that is or what that isn't. Or the 39-page document I got from one attorney that every single thing he could think of. Well, what if he didn't put in there the cardiac arrest from a potassium deficiency? Because not a lot of people know about those things. What do I do in that case? You covered every other single thing you could imagine. So lots of problems with what you're seeing. Other kind of problems here with advanced directives, just generally. The form can substitute for conversation. I was talking with David earlier and pointing out I think some of this is just the two professions we have involved here. The legal profession, if you give them forms, boy, they're happy. Forms, paperwork. There it is, written. This is wonderful. It's really important, and sometimes you'll find that people give more weight to them than you actually should, more even than the states will when they write the statutes. Some statutes just say they create a presumption of what you want. They don't always say that you have to go and follow them in that way. Physicians are busy. You give them paperwork, they're going to say, great, I'll just hand you the paperwork. I'm not going to have the conversation with you. I can just do it this way. Look, it cuts off so much time. We have so many other things we need to talk about. So forms can be problematic given the other circumstances of what you're dealing with. They can lead to undertreatment, and this is patients' biggest fear. Why do they lead to undertreatment? Well, I have gone into cases where you'll see someone who will say, and you'll talk to about the treatment plan, and you'll say, well, why aren't you doing this, or why are you doing that? And the answer will be, well, they're a DNR, or they've got an advanced directive. What does it say? Well, I don't know what it says, but, you know, that just means that they must have written it because they didn't want treatment. Now, I wish I could say it never happened, but the truth is it does happen. And I think it's problematic enough that we should be particularly cautious in how we use these forms and how we promote the forms. If not only are they leading to fewer conversations between physicians and patients, but they're actually leading to fewer thought processes about what kind of treatment should occur in particular cases. Now, other people have pointed out, the other problem with these things, they sort of put a lot of emphasis on the idea that you're actively dying at a particular time. In other words, that there'll be a point in time where you need to make this kind of decision, as opposed to the fact that it's always a continuum. You're always making a variety of decisions about things going on in your life, about health care, and the notion that there's a point where these kick in suddenly. Suddenly you'll be in the state where an advance directive kicks in, and other times you're not. And we're not thinking more broadly about making health care decisions throughout your life. It's also on sort of the other side of all of this, what if these things were really great? Well, the truth is, even if they're wonderful, it's not clear whether there are any penalties from ignoring them. There are only a couple of cases on this. The few cases that we've seen, courts have been unwilling to hold physicians accountable for ignoring an advance directive. Now, they do this because of what we talked about in the beginning. There's sort of an emphasis on physicians providing treatment. We don't want an emphasis or a situation where physicians are thinking, ooh, I could get sued if I provide treatment. I better be careful here. So there's a reason why the courts are hesitant to put in place penalties, but the end result is that you could be dealing with a situation where legally the documents just don't hold enough weight. They don't do what you hoped they might do in situations. The other problem, I think, consistently comes up in a variety of cases, and that's the incompetent revocation. We have yet to figure out what to do with the person who fills out an advance directive but can talk to you enough to say, yeah, I don't really want that. Or you walk in, and there's a case that Michigan had when I was there, Michael Martin case, and the man was conscious and able to communicate, clearly incapable of making his decisions, and they walked in, and his wife said, withdraw treatment, and they said, do you want to die? And he said, no. I don't know what you do with that information. As things stand right now, as the person decompensates to the point and they have an advance directive in place, we had a situation of this with someone who was mentally ill, and as they decompensated to the point where they were no longer competent to make decisions, and they had designated the person to make decisions, and their feelings of paranoia and persecution became quite evident caused by their disease, and the son who was supposed to make decisions came into the room, and the mother said, you're out to kill me, don't, get out of here, you're not going to make decisions for me. You get sort of a strange effect, and at that point, no one was willing to let the son make decisions in exclusion of what the mother was saying. And we knew we were stuck. But we have yet to fix how we deal with these incompetent revocations, because of course once you're incompetent, you can't put in place someone else. She couldn't have said to us, my son's trying to kill me, you better talk to my daughter. Because the son's trying to kill me, the incompetent revocation revoked her proxy designation. But the talk to my daughter was an incompetent designation of a proxy, so it didn't kick in. So you sort of wind up in this bizarre legal, gray land where you're not sure what to do with some of these things when you actually put them into practice. Now, I don't mean to imply then that we should throw them out and they're horrible. What I want to sort of stress to you is that they're limited, and that they won't solve all the problems. But I do think they play some important roles, and some of these might have been helpful in Terry Schiavo's case, and they might not have been. The first is that they're pretty helpful for unusual preferences. And oddly enough, they are helpful for someone who would say, for example, I want treatment continued no matter what. So if you have unusual preferences or other kinds of things that you might want to stress, they can be particularly helpful there. They're helpful for people who are anxious about things that you can put into a formal advance directive. So they're really worried about X kind of treatment happening or not happening. I never want to have this particular situation occur. They can be helpful in relieving the anxiety. I can't tell you for sure they're going to be helpful in fixing the situation when you actually get sick for all the problems I just told you about, but they can be helpful in relieving anxiety. They can structure discussions. They can help you have the discussion with the healthcare provider or with your family. They can be particularly helpful in states, and there are a few of these right now, where you need either a fairly high degree of evidentiary certainty of what the person would have wanted. Here you have a document that might state it. Or for a number of them now, whose advance directive statutes say things like, for food, nutrition, for food, hydration, and respiration, you need to have specifically told us these are things your proxy has authority to do. In other words, in the absence of some clear written designation, not of exactly what you would have wanted, but at least that your proxy has that authority, we will not automatically assume your proxy has that authority. And in those states, it can be fairly important to have some kind of written designation of that. And most importantly, they can appoint your surrogate. So they can function to not only structure the discussion you're having with your surrogate about things you want or not, but they can appoint them. They're useful for unusual designations outside a next of kin hierarchy. So generally speaking, we would go through a next of kin hierarchy, even in those states that don't have statutes that do that. Some states have statutes that say, here's the next of kin hierarchy, here are the people you go to. There are a variety of states that don't bother with that by statute, they do it informally. In the absence of any proxy designation, we are going to go to your spouse. In the absence of a spouse, we're going to go to, we're going to parents, we're going to go to adult children, we're going to go to your siblings, and you'll go through the whole hierarchy as to who you want to have. If you want to skip outside of that hierarchy, I know my parents won't make decisions I want my sister to make them. I know I want none of these people to make them, I want my companion to make them to whom I am not married. Those kinds of things would be very important. The other part of it is it gives authority. It not only gives legal authority, but I think it also gives to the person a certain sort of psychological comfort level. I trusted that you would be the one who could make these decisions. And for families who have that proxy designation, I honestly think that they are more comfortable making decisions when they have been designated through a proxy document than they're informally designated as next of kin. In other words, especially if you've given them a specific authority saying, and you can make decisions to withdraw life-sustaining treatment, including food, fluids, and respiration. In those situations, proxies tend to feel as if they have been given the authority by the person and more comfortable then being able to make some of these kinds of decisions. So they can have some extremely important roles that they can play, and they're sort of not useless, but I don't know if they would have solved the problems that we had in the Terry Schiavo case. All right, lesson 4. So lesson 4 is that it turns out that the key thing in these cases is not necessarily advanced directives, although they play a part in this, but surrogates and proxy decision making. This is where we need to be spending our time and we need to be spending our energy. We need to be educating surrogates, educating them as to their role, what they need to be doing, what they need to be thinking about. We need to be thinking in more detail about the support systems we need to put in place for surrogates making decisions and how to instruct them and help them in making proxy decisions. Who are surrogates? I already mentioned. Obviously, surrogates are going to be, they're going to be a wide variety of individuals. Most likely they're going to be spouses, parents, adult children. They're going to be some members of the family. In some cases, they're going to be more than one person with legal authority, either because someone designated more than one person, or because, more likely, there's more than one person of equal status. So if you didn't designate one individual, and we're looking at siblings, and you have 3 siblings, all 3 of them will be of equal status and able to make decisions, legally at least. It's not clear whether you should be going to all 3 people, depending on their relationship with the individual in question. How are they making decisions? Well, in theory, they're making decisions based on one of 2 standards. One is a best interest standard. Do you know what would be in this person's best interest? Here, usually it's discussed as a best medical interest, although it's clearly broader than that. So you do clearly get to take into account something besides specifically medically what they would have wanted. And there have been cases which have looked at sort of impact on the family as a whole. There have been organ donation decisions between incompetent siblings which have looked at sort of impact on losing the sibling, who's a major part of your life. So it can be a little bit broader. Best interest should be used in cases of never competent individuals or for those where you have so little evidence of the wishes that you can't make a decision based on those wishes. It's pretty limited. There will be rarely times where you can use best interest standards to withdraw life-sustaining treatment. We haven't seen many cases on those things. There have been a few, and the few that didn't think hard about best interest. So the ones that we have court decisions on didn't really tell us much about how you do this in a best interest notion. They say things like, well, and Quinlan's an example of this, she's in a persistent vegetative state, so of course nothing would be useful to do. We can just, that's not a good state to be living in, essentially. But not really an analysis of what does it mean to be talking in terms of someone's best interest. Now, that's important. That's important to let surrogates know. if you're using a best interest standard, it's pretty limited. The other standard that you're going to be using and most likely going to be using is a substituted judgment standard. You don't substitute your judgment for the person's. The idea is that you're trying to figure out what their decision would have been if they were now able to speak and tell you what they would have wanted. Now, important to realize, for never competent individuals, this is a complete, both of these are legal fictions, it's a complete fiction. So it is ridiculous to talk about substituted judgment of a neonate. It is ridiculous often to talk about substituted judgment of a child in most cases, unless the child is above the age where you might say they would have had capacity to make decisions. It is ridiculous to talk, as one court did in Massachusetts, about substituted judgment of somebody who is always been severely developmentally disabled. Why is it ridiculous? Because they've never been competent. You can't tell me what would it have been like to be competent. I've seen people suggest, we should be talking about substituted judgment in cases where you think to yourself, well, it's hard enough to decide what would the person have done if they had been here competent. Well, they're not here, and they're not competent. Try doing that with someone who's never been competent, never given you an indication of their wishes. These are things to educate surrogates about. Tell them about the standards they're applying. Tell them how. I've had surrogates say to me, oh, substituted judgment means I substitute my judgment for theirs, right? Why not? It sounds like it. If you don't tell people what we're asking them to do, you can't assume that they're going to be able to make decisions. And then there are levels of certainty. Some people view these as actually safeguards that states have put into place. And this goes back to remember the first slide I said to you, we know you can make decisions. You have rights to make decisions about your medical care. We know they don't disappear when you're incompetent, but we do know that some things change. And one of the things that changes is that you are no longer here to tell us what you wanted. So we as a state can be cautious, appropriately cautious, about how much we're going to listen to your proxy without being really certain that that's what you really would have decided. In other words, a state can say, instead of saying preponderance of the evidence, it's more likely than not that this person would have wanted treatment withdrawn, we can say that you have to know with maybe 75% certainty, clear and convincing evidence that this is what the person would have wanted. Now the evidentiary standards come from other kinds of cases. They come from civil and criminal cases, and they're not a good map. If you ask someone, what's 75% certainty? I don't know what 75% certainty is. Quite frankly, I don't know what 90 to 99% certainty is, the beyond a reasonable doubt. What's a reasonable doubt kind of thing. But we do know that what we're saying to you is, in these kinds of cases, you need to be more certain than just, yes, I think it's more likely than not that's what they would have wanted. And we don't put this into place because we doubt you as a surrogate. We don't put this into place because we think you're doing something wrong. We put this into place because it's an approximation of your autonomy. You're no longer speaking to us. All we have is someone else telling you what you would have wanted done. And in that case, we have to be comfortable with what you're saying, and we'd like you to be pretty certain that's what they would have wanted done. Now, it's been used in different ways, in some ways problematic. One of the problematic ways that it's been used by a few courts has been when you look at the decisions, it looks like nothing but written instructions would have met the level. And if that's the case, then we're all sort of stuck, because the vast majority of us don't have written instructions. And if that's the case, boy, we all better get out there and be writing advanced directives, even with all of their flaws. But I think that's a misinterpretation of what the level of certainty would mean, what clear and convincing evidence would mean. But I do think that it means you're going to have to provide something else besides, this person said the other day, randomly 10 years ago, that they never wanted to be a vegetable, and that's why I'm doing this. That's not going to make it. So what is going to make it? Well, I don't know exactly what, but I do know that we get to look at lots of things. We get to look at your written wishes, but we also get to look at your oral instructions, reactions to medical treatment of yourself or others, religious beliefs, actions during life, anything you can think of to tell us what it is. Now, sometimes you're doing that in the context of a courtroom, but rarely. What I'm saying is you need to be able to inform surrogates that these are the things you should be looking at and gathering for themselves the amount of evidence they need to be certain of the decision that they're making. And you'll think about things like remoteness. How far away was it that you're remembering something? Was it during the time that they were sick and already experiencing things, or was this 25 years ago? Consistency. Were these statements sort of consistent with what other things you know about their life? Thoughtfulness. Was it an off-the-cuff comment? The very interesting thing about the Nancy Beth Cruzan case is some of the testimony had to do with her comments to her housemate after her housemate's sister was in this sort of horrible accident and then dies. And these kind of comments about, well, it would have been worse, you know, to have her live in this nothing sort of state. Wouldn't that have been worse? Now, were those comments because she was trying to console her roommate? You know, think about the options here. It's awful. Your roommate's sister just dies. You might say, well, it could have been worse. You know, she could have lived, but never knowing anything around her. Or is that really an adequate reflection of her feelings about the situation? Maturity when you said these things, and specificity. You know, how specific were you about what you were talking about? These are the kinds of things and the kind of information that you might want to work with surrogates and provide. I've suggested to institutions before creating information sheets about the standards, when you apply them, and what kinds of information you might want to use. So you help people make these kinds of decisions. All right, lesson 6, family disagreements. These are real families you're going to work with, and families are complex. Families at their simplest are complex. You know, even the ones that you think are relatively normal. I had some bizarre conversation with my husband and my sister-in-law about a week ago. We were on vacation, and my husband said something about the family, and his sister turns around and she said, "It's called dysfunctional." Yeah, you know, families do strange things. I think it is striking that in the few very high-profile cases that we've seen in arguments about withdrawing end-of-life care, we have seen spouses line up against parents. I think it is impossible as a parent myself to conceive of your child dying before you. It is just inconceivable, and that is not to say that there are parents that cannot make some very difficult decisions, but it literally is inconceivable. Whereas as a spouse, it is possible that your spouse predeceases you and you lived a life before you met your spouse. You can imagine your life without them. And I joke with my mother now that it's almost hard for me to remember what it was like before kids. They become such an integral part of who you are. It is very difficult to ask parents to make those kinds of decisions. It is not, I think, surprising then that the cases where we've seen the really serious battles have occurred between parents saying, no, you cannot withdraw treatment, and spouses saying, yes, this is what the person would have wanted. If you add to that the fact that your parents at the time where they probably knew you best in describing what you would have wanted, knew you young, vibrant, the time where you lived with them was a time where, you know, you didn't have any infirmary, you didn't have any problems with your health likely, and that your spouse is dealing with a very different interaction with you. Underlying family dynamics, there were some interesting discussions in the Shivo case that this was just her parents. Eating disorders are sometimes, they're usually long-standing. They often occur in teenage years. They often occur because of family issues. And there were some people who pointed out that this was just another attempt of her parents to control her food. It's not clear to me that's what was going on in this case, but it makes you realize that there's lots of stuff going on in this case. Enormous amounts of stuff going on in this case. And family disagreements are going to occur whether she had an advance directive or she didn't have an advance directive. There was something going on in the debate. And if you even look at the timeline, it took her husband 8 years before he said this is not how she wanted to live, which meant at least 5 years beyond the point where the medical and treatment team said to him, we're not going to see changes. So it took him a long time before he was willing to say this. And parental disagreements occurred just at various times. Lesson 7. We don't train anybody in medicine to disclose uncertainty, despite the fact that medicine is filled with uncertainty. We create a very bizarre situation. We create a situation in which you have to somehow be very authoritative and tell patients exactly what can happen. Patients expect that you're going to give them real, specific information. Is there absolutely no chance that Perry Shivo could wake up? Well, no, there's not absolutely no chance. It's all probabilities. Almost all of it's all probabilities. For patients in a situation where they're sort of expecting to hear you're going to give them a definitive answer, and your inability to give them the definitive answer, and your inability, in part because nobody ever trained you in how to think about uncertainty for yourself and how to then communicate it to patients, it's going to cause a lot of problems. Now, the autopsy in the Shiloh case showed it was, quote, consistent with PVS. Why did they phrase it that way? Well, because nobody wants to say it's exactly PVS, in part because of there's some difficulty in deciding whether you're talking about a persistent vegetative state or a minimally conscious state, and that these are lines that aren't that don't match up exactly with characteristics such that you can say here's clearly this group of patients and here's clearly this group of patients. Well, the response to the autopsy report by one of the Right to Life groups was seeing she wasn't in a persistent vegetative state. He just said consistent with. If she had been, they would have said she was in a persistent vegetative state. It's sort of an amazing disconnect between the reality of science and medical care and the understanding of uncertainty and the role it plays and the way you make decisions in the face of uncertainty. I think that one thing this case shows us is the importance of thinking more clearly about how we deal with uncertainty and how we discuss uncertainty in diagnoses, in prognoses, with patients and with families. Media spotlight on the rescue syndrome. You know, the idea that you have to, rescue someone who's dying right in front of you, that pervades medicine. Well, that pervades the rest of the population too. She was dying right in front of us. There had to be something we could do. That's what was going on with the legislature. We must be able to do something. She's dying. And it was only afterwards that some of the legislature started to say, oh, you know something? I'm not so comfortable with what just happened. But at the time, it's very hard to see anything else but that it's an emergency situation. I've had battles with jobs I've had before when I was doing ethics consultations on a more regular basis about whether I had to wear a pager. And my feeling was there's no emergency ethics consultation. And they were like, oh, we have to reach you. Oh my God, something could happen. We'd have to talk to you right then. And I thought, no. Probably not. A few places I lost the battle and had to walk around with the pager, which I inevitably left hooked to my pocketbook across the room. And then it would go off the entire time, and I'd be sitting there going, boy, that's obnoxious. Nobody's turning that off. And yes, it was mine. It is hard to sort of not feel like you should be able to do something. 15 years since the accident, 8 of which we were treating her the entire time. 7 after the first point where her husband said we need to withdraw treatment. Numerous courts, numerous things going on. And it was hard each time I got a call from someone in the media to try to convince them that this wasn't an edge-of-our-seat emergency, that this had been going on for a long time. Clearly that's some of what went on in this. Now, other things went on that were bizarre, by the way, with the legislature. Lots of people were very willing to provide a medical diagnosis without having examined the patient or the medical record. I was amazed by that. Many people without medical degrees, too. So, there's sort of an interesting phenomenon going on in all of this. But there's something that is very seductive to us about this, and there's something that we need to realize that people are responding to. Lesson 10, role of courts and legislatures. All right, vast majority of these cases, 99.9% of them don't happen in the courts. I can never convince people of this. I can never convince my law students of this, because they sit and read all of the cases. You're seeing such a small fragment of cases. These things are decided every day by hospitals and treatment teams, and they don't get into courtrooms. By the way, they're never decided by legislatures. This was a first for us. So the idea that it got even into 2 legislative systems, the Florida state legislature and the U.S. Congress, was unheard of. These are things that are decided behind the scenes. Now, the spotlight can help. It can help us see where things are failing. It can help us see where we might want to add more attention. But I don't want you to take from this that this is where we're going. Everything goes to a court. I was down at the University of Virginia just after the Baby K case was decided, a case about an anencephalic infant. And a couple things I got from that. I sat in a grand rounds on it just after the case was decided. Or soon after the case was decided, and I had someone stand up there and say, well, now, the law is this because the court has decided. I said, what court? Well, the court down there, the Fourth Circuit. It's the Fourth Circuit. Well, it's an appeals court. It's a federal appeals court. It doesn't determine the law of the land. And by the way, it is the Fourth Circuit, so, hey, you can write it off to a certain extent, too. It was this bizarre, well, the court has said, well, and other people would say to me, well, there's a question here, let's ask the court. And I'm like, are you just going to knock on the door? Court! How do you ask the court something? These are not bodies that are designed to answer these kinds of questions. These are bodies designed to answer what are primarily process questions. Did you do the right process? Is the appropriate guardian in place? They do serve as a check, but they have to in a specific case. And you have to give them a specific question. You can't go to them and say, tell us generally what we should be doing in end-of-life care. First of all, by the way, courts are likely not to answer your question, and if they do answer a question, it's likely to be a different question than the one you asked. Now, that, by the way, happened in the Baby K case. They wanted a decision about futility of treatment for an anencefalic infant. What they got was a decision on the Emergency Medical Labor and Treatment Act. Well, that's not what you wanted, right? Courts decide very narrow questions. You can't expect them to answer these kinds of things. So lesson 9. This is Dworkin, sort of different views on how to respect human life. We are still arguing about these things. Terry Schiavo gave us yet another opportunity. We see it in our abortion debates, we see it in our stem cell research debates, we see it in the cloning debates, we see it in the physician-assisted suicide debates. How do you respect human life? If you assume the best motives from all the parties involved in this case. This was a debate about whether to give weight more to the value of life as instrumental value, part of the value of having lives in our society, the value to other people, the value to our society, subjective value, value to that person. What do they want their life to say? What do they want their life to do? And the notion that life itself could be sacred or independently valued. Not incrementally, not that we want as much life as possible, but that once there is a value to it. A value because there might be a natural investment, or some people would say an investment by God, or value because human investment. Her parents raised her. Her parents put life into who she was. How do you value those things? How do you weigh those things? I don't know the answer to that. I do, however, know that we are still arguing about it. And I know it comes up in these cases just as much as it comes up in the other kinds of cases. And it's important to realize that very much at base, that's what was going on in the very public debate over what was going to happen to Terry Schiavo. Now, law provides no process, no basis for making the decisions between these things. It provides a process to a certain extent, but even there, law doesn't give you the answer between these things. And I do think this is where ethics plays a role. And when people say to me, so what do you do when you do law and bioethics? Most of the time what I do is I tell you what's out there in the law, and you know this more than anyone, tell you what's out there in the law, and then I tell you why it doesn't solve all your problems and where you're going to need to draw from other things and draw from ethics. So this is where I think these are the kinds of things you have to draw from other places. This is my one cartoon for you. Let's just say I've lived up to the highest moral code permitted by law. And I would hope that in none of the situations about Schiavo and for none of you that this is sort of the baseline against which you're judging yourself. All right, I think we should have a bunch of time for questions, so thank you, and I'll open it up for anybody who'd like to ask anything. Go ahead.
I have a question. At what point is the family taken away and the court appointed as the...
In no situation should a court be appointed as a decision maker. So the court will play a number of different roles. If you have a situation in which there are members of the family who are arguing, they may go to court, and that's what happened in this case. The parents can go to court and challenge a couple of things. They can challenge who is the guardian in question. So they could go to court and say, Michael, you're not the right guardian. We're really the right guardian. Or they could say, you're the right guardian. We don't challenge you as the guardian, but you're not making the right decision. You used the wrong standard, best interest versus substituted judgment, or you used the right standard, but you didn't consider all the appropriate evidence. The court should review that. Although it is true in some cases it looks like the court is making a decision, in no case should the court be making the decision. They should be evaluating the decision made by the appropriate guardian in the particular case. There are situations where hospitals have said, this family is making decisions that we don't think are appropriate. The hospital certainly could go to court and say, these are not their appropriate decision makers. More often than not, there's some negotiation that they attempt between the family and the treatment team, and if nothing works out, sometimes a transfer of the patient. But there's no point at which a court sort of automatically steps in. Someone has to go to the court and challenge the decision maker, who the decision maker is or the decision that they're making.
You mentioned at the very beginning of the discussion a malpractice settlement, and that's something I actually hadn't been aware of or had forgotten. I wondered what that was, and did that complicate this issue? I usually think of these things, the doctor taking care of it, working with the family, and it's over. Did malpractice get in the way here?
So the question is sort of, what did malpractice get in the way of the thing? I know I'm supposed to repeat the questions. I'll try to do that. It's kind of interesting. The first disagreement between the family and the husband occurs just past the malpractice settlement, and the husband at that time claims that the family is demanding a share of the $300,000. And it's not clear whether that's just, again, just a breakdown between the family or what's really happening. That's significantly before, at least 5 years before, he actually asks for withdrawal of treatment. But at that first time, I remember I said the family early on, they had a disagreement about treatment and went to court saying he's not the right guardian. He claims at that time that that's what was going on. They were debating about this $300,000. At the time of the withdrawal, he says there's really no money left in the $300,000. There's really nothing at stake here. And $750,000 was put into trust for her initially. So there was nothing you could do with that except use it for her care. And that's likely to have been used up also. There were some debates about whether there was money somewhere floating around, but $750,000 is not a lot of money. And for 15 years of care, you know, at the level that she needed it, that was gone early on.
I was getting at, maybe more specifically, what was the basis of the malpractice? And did that keep the family then from having confidence in the doctors and hence then following their advice on how to proceed?
I have no idea if it had a difference in the family's confidence in doctors. Possibly. I have no way to even evaluate that. I don't know the details of the malpractice suit. I know it had to do with the initial actions when she was first brought in, but I don't know the exact details of what it was or whether or not it would have formed a good basis for why they thought something different would happen. Now, they certainly had doctors they were comfortable with, and even the parents had other physicians and other people that they pulled in to make determinations. So it didn't turn them off to medicine completely. I do think that a lot of what was going on in that case was sort of, they were focused on the fact that their daughter was not in a persistent vegetative state and that there was a chance for her to continue to interact. And arguably, although she didn't interact at all on her side, given what we see from the autopsy, she interacted with them on their side. In other words, she played a role in their family, and that part of it they were unwilling to give up. So I don't know how much it made a difference, or would it have made a difference, but clearly there was something going on there. Other questions? All the way in the back.
You know, we kind of stumble around the issue of lacking decisional capacity versus competency, and you use competency throughout this lecture, which is a lawyer term. At the hospital where I work, we talk about decisional capacity. So what's the difference? Okay,
the question is sort of the difference between capacity and competence. I sometimes start people at the beginning of lectures and I warn you that I might go back and forth between the terms. They are distinct terms. Capacity does have to do with medical and mental health determinations about the person's ability to make decisions, whether they have capacity. Competence, and in this case, because we knew she had a guardian in place, she'd been adjudicated incompetent. Courts determine competence. They should determine it based on capacity. So, you know, they shouldn't be sort of totally separated from each other. A judicial determination of incompetence can only be altered by a court. So we try to avoid doing that in a variety of cases. So someone who has fluctuating capacity, you might be better to just make medical or mental health determinations about when they're capable and when they're not. If you put in place a guardian, then you're going to have a court take the guardian off at the point the person has regained capacity. So they are different things. So legally, competence is determined by a court and by statutes. Statutes will say to be competent to make medical decisions, you need to have these kind of factors. And capacity is made informally all the time. In fact, you're supposed to always do this. We rarely do it. As soon as your patient says yes to a treatment, almost nobody questions their capacity. You're sort of supposed to even then think, is this person capable of saying yes to treatment? It's usually the trigger is someone says no to some kind of treatment, and then there's sort of a flurry of activity. Shiva was not a case where we had to really worry about that. One was there's really no doubt about her capacity, and second, we actually had a legal determination she was incompetent and a guardian put in place. Yes?
Can you talk about some of the varying definitions of persistent vegetative state? I've read an article that can be an issue on why legislatures don't want to define some of this more clearly, because the term, if you ask 5 medical experts across the country, what they describe as persistent vegetative state might differ among all 5 experts.
The question is sort of determining the definition of a persistent vegetative state and why it varies. You know, this is the problem all the time when you try to legislate in any area and you don't use specific medical terms. Persistent vegetative state is a description of characteristics. It's not like saying, you know, I think someone who has this percentage of brain activity in this section of the brain has this thing going on. It's sort of a global cluster of things that says, well, you're in a persistent vegetative state. And there have been discussions about how we draw the line between PVS and MCS, minimally conscious state, is not as clear, and that some people would fall into one or the other, and then there's been a few studies where someone has gone in and checked everybody who, you know, they would say would be in a persistent vegetative state and said, oh, well, only this proportion meet the criteria. You know, I see this recently actually with the attempts for partial birth abortion legislation. Same idea, is you're going to take a term that's not a medical term and try to apply it in a context legislatively. It might speak more to the difficulty always of legislating in a medical context specific to a particular diagnosis. In other words, it seems odd that we would have legislation that would say, if someone was in this state X, then you can do these things, rather than one that would say, if someone wants to make decisions about life-sustaining treatment in any state, we're not going to try to figure out whether you meet this specific diagnosis. Then, you know, you can make all the decisions that you want. So I can't tell you, I mean, I know there's disagreement about the issues about what is a persistent vegetative state or not, or whether we should use the term or not. Some people object just basically to the notion that you would use this term or you would try to distinguish it from anything else. I do think it shows a sign that you ought to be cautious in legislating something that would say anybody in a PVS, you can withdraw treatment. Because then you're going to put everything on the weight of, is it clear that they're in a persistent vegetative state, and what is that? And especially for an area that doesn't match up specifically with something that you could measure and say, well, it's X. I mean, even if you think about, you know, how much trouble we have with brain death criteria. It's a cluster of characteristics, and it's time-sensitive, the definition. You have to meet these characteristics for 6 hours before you're brain dead. Does it mean your situation, your medical situation changed from, you know, hour 1, 2, 3, 4, 5, 6? No. It's just that legally we had to create the situation, and when you do that, anytime you do that, you're going to have some difficulties in interpretation. Yes?
Would you comment, please, on the observation that someone made, that this is less an issue between medicine and law than it is an issue about social dynamics and religious conflicts?
All right, less an issue of medicine and law than an issue of social dynamics and religious conflicts.
You want me to expand on that?
You could, but I mean, my immediate reaction would be, I mean, isn't a lot of what we do in law and medicine an issue of social dynamics and religious conflicts? So the idea that we separate these out some way, I don't think, if what you're saying is, it's not an issue that medicine went one way and the legal system told it to do something completely different. I agree with that. But why did we have the mess in the medical evaluation has to do with, I think, social dynamics and religious values to a certain extent. And why did it get into the courtroom? Because right now that's the one place we have to solve it, which doesn't solve it, as I pointed out, but the one place we go to to solve it when we have these conflicts. We don't have a really good mechanism right now to mediate through our religious issues and our social dynamics. We don't have it, so we turn to the courtroom. I think it's a very poor place to deal with those kinds of things. So I don't disagree that underlying it is a lot of other things that are going on here. It wasn't just that, well, the law failed us in providing a nice little framework and medicine failed us in providing really clean diagnoses, and therefore that's not working. I think it was a lot of the different things in there.
We seem to have a group of people who are simply unhappy with even resorting to the court system. And unless they replace the current judges with judges who are like-minded with them, that they will not settle for any other solution or resolution of these complex issues. So that, in part, it was this dynamic that compelled it to go beyond the courts. In other words, why did this ever make the legislature of the state of or why did it ever try to get beyond that? There's a group of people that just don't like what might be the outcomes of some of these complex issues, and they're determined to impose their point of view upon similar cases.
I think that is fair to a certain extent, to say that some of this was really prompted by people unwilling to accept, no matter what the determination, any decision that wasn't going to be a decision, along the lines that they liked it. But, the hard thing about that is that, and that's what I was trying to show in my, not my cartoon slide, but the slide before that. We do have an underlying debate in our society about how the best way we're supposed to respect life is. And for people who feel extremely strongly about these things, it's not up for negotiation. There's no consensus position. There's no compromise on this. Now, one response to this has been, well, we provide a process. And if we go through that process, you have to accept the outcome, whether you like the substantive outcome or not. To a certain extent, that's what our legal system does. Other people will respond, well, that's just not good enough. Substantively, you've got to come out the way I think you need to substantively. Maybe you have to change presumptions that are in place. Maybe you have to change the process. Or maybe you just need to find the person that rules the way you want them to rule. Now, we haven't solved this in some very difficult issues. And my point in this was, we're not going to solve it here in the context of one case. I think it just lets us know that, like the debate we're having right now about abortion, these are underlying debates within our society about how we're supposed to do this. Now, I don't tend to think that the end result is we'll throw up your hands and discuss, we'll never figure anything out. But I do think we need to realize that it's much more than just the breakdown in one case. There were other things going on here, and it's much more about what kind of society we choose to be and how we address what are clear differences in the way that people feel that we should be dealing with not only these kinds of issues, but fundamentally respecting life in different forms. And, one side says we do it by letting individuals make decisions about what life they want to lead and when they want done leading it and what kinds of treatment they want and what happens to them. And others say, no, we respect it by maintaining it because it's not yours subjectively to control in that way. There are other values that we're dealing with here. That is apart from what is, clearly in this case, also a breakdown on who makes decisions and families and what's happening. So it plays itself out in a lot of different places.
I work for an HIV clinic, and most of the patients are gay men. So in the case you mentioned that states often have their own hierarchy, the advance directive can say the partner makes the decision. Does the state always recognize that, or have you seen battles over that too?
Oh, so the question is, you work in an HIV clinic for men who make proxy designations for their partner as opposed to the next of kin hierarchy. Do states recognize those things? Generally speaking, yes. They should recognize all valid, as long as you've observed the correct forms, all valid proxy designations. States will also recognize proxy designations of other states, even if you've used a different form, so that should be fine. Yes, there have been some battles in the same way there have been battles here, not as visible, where family have come in and said, you don't get to make the decision here. You might argue the person was incompetent when they made the proxy designation. My understanding is most of those don't really go very far. You should be fairly confident that your proxy designations are observed. And so there are rare situations where there might be battles, but those are places where I think advance directives do a lot of good. Other questions?
One intervention you talked about healthcare providers might want to pursue is educating and supporting surrogates in being a surrogate and the process they have to go through.
Mm-hmm.
Are there any interventions that do that? Like what would that look like?
Well, one thing that I've suggested times has been to simply have information forms for surrogates describing what is the best interest standard, what is a substituted judgment standard, what kinds of information, like I gave you a list, what kinds of things should you be thinking about? You know, you don't think about, did they ever write anything? Do you have an advance directive in front of you can look at? Think about, did they ever say anything to you? How did they react to treatment, religious beliefs? I mean, you can think about, you can give them information. What are you supposed to look at? Because sometimes practices will look at you and say, well, how am I supposed to make that decision? You say, well, look at all of these kinds of things. You might, especially if you're in a state that requires a certain level of certainty, also try to explain, you need to be fairly certain. We need not just more likely than not certain that this is what they would have wanted, but you need to be, you know, greater than this. You know, you can use percentages, you can use descriptive terms. There's ways to kind of think about how do you give proxies enough information so at least they're not making decisions where they just don't have an idea at all about how they're supposed to go about that. And there I think, you know, I've seen places think about, you know, should you create a little booklet, you know, you're a proxy, now what do I do kind of thing. You know, and you can describe some of these things to them. Hopefully you also have some conversations, but for proxies, it might be really useful to just actually lay some things down for them. You know, here's what kinds of things you're going to be asked to do, as well as you're going to be asked to be making lots of different decisions. Some of these are going to be easier to make, some of them are going to be harder. At all points you have the right to get as much information as you like and to ask questions. I've gone into consults where the proxy is not aware that they could have gone back to the healthcare provider and asked questions because they thought, well, I'm not the patient, so I just listened to all the information, and they're confused on one minor point that they just didn't think they could ask anybody about. So there's a variety. I mean, I've seen the little information documents for patients that say you're a patient and here's what your rights are. I think it'd be useful to be sort of, you're a surrogate or you're a proxy, here's what your responsibilities are, here's what kinds of, you know, here's the resources we have for you. Yes?
You talked about the media, the role of the media and the legislator in one of your slides. And can you talk a little bit more about, I guess, the likelihood of this happening again? Or do you think the legislator would just move to it and you don't think that'll happen again? Or what's your sense about all this?
Well, someone told me just after this, the question was, what do you do with the media and the legislature? Was it likely to happen again? And someone said to me, well, right now, and I can't remember whether it was a response to a cartoon that they saw, or they said, I know what I'm writing on my advance directive. Under no circumstances do I want the Florida legislature, Governor Bush, or the U.S. Congress making decisions about my health care. Is it likely to happen again? Well, you know, this isn't the first time that Governor Bush has tried to interfere in a case about health care decision making. The one before this was a developmentally disabled woman who was pregnant, and there was a question about whether or not to go ahead with an abortion. So is he likely to interfere again in a case? Possibly. The Florida legislature seems chastised enough by the decision that their Terry's law was unconstitutional that even in that case they wouldn't pass another law. So they might be aware. And I think even the U.S. Congress started to back off in thinking there were problems. But that didn't stop a number of legislators in the U.S. Congress from calling for impeachment of judges deciding the cases who they felt shouldn't be making these decisions because they didn't make them the right way. It didn't stop the fact that this is still a political issue, and that there will be people who will go up for election and there will be political decisions made. So is it possible it happens again? Yes. Is it possible it happens on this scale again? I think unlikely, only because you'd have to get the groups that at the time were like motivated, oh my goodness, we have to do this, we have to do this, even right after that started to say, we ought to be more cautious. Maybe we didn't do what we needed to do here. I'd like to hope, I guess, that it doesn't happen again.
It's a social gender question, so softball. So why is it, do you feel that the cases of Karen Ann Quinlan, Nancy Cruzan, and Terry Schiavo, all young women, have reached such national prominence in the media?
It's a softball question? Why have young women, right, that's masquerading as a, why have cases of young women reached such prominence?
When we know that such cases have occurred in other
Yeah, although, well, maybe Martin didn't get as much play. Michael
Definitely
Martin,
not outside of
right, not outside of Michigan. Quinlan, it's not clear to me that Quinlan got the same play. I mean, some of these get play. I mean, Quinlan was a Supreme Court case. You're going to get play on that no matter what. So, and Quinlan was a New Jersey case. Quinlan got picked up legally because it was one of the earliest cases, so became the case to teach. Doesn't actually teach you very much, by the way, legally, but
publicly in the media, it was on the front page of the Times.
right. I mean, it's a big deal that you had this thing. I don't know. I mean, there's so much in gender politics that, you try to figure out why it is. We do have some weird data about whether or not, we have weird data about women being caregivers for long periods of time in situations, and we have weird data about listening to women's determinations, particularly young women, about whether or not they're ever really certain about what they say, or whether you should second guess them. It's possible. I don't know.
They all have Ulysses contracts.
Right, right, exactly. It's possible that that's part of what it is. What you try to deal with here is the realization that 3 cases is just not a representative sample of anything. I mean, I don't know behind the scenes how many times people, really scrutinize family decision makings for young men versus young women. I don't know that because it's all done behind the scenes. I have no way to judge. So the fact that these few came up, I don't know the answer. I would like to think that, you can still throw a penny and have 3 heads come up. So I would like to think that we are not in as bad shape as we are, that I know sometimes we are in terms of gender politics. But maybe it's part of the reason that we're seeing those. I don't know.
Any other questions? I want to thank our speaker for the